Good morning, everyone. Thanks so much for joining me here on this Friday. We are going live to Frankfort right now, where several folks are getting together, including the widow of Tommy Elliott. That is a victim from the Old National Bank shooting that the horrific experience that we had here in our local community at that Fifth Third bank mass shooting. And also Whitney Austin. From Whitney Strong is also going to be talking today. The topic is gun safety legislation. They're getting started, so let's listen in.
Morning, I'm Rick Sanders, currently Chief of Police in Jeffersontown, Kentucky.
Chairman, thank you. Members, thank you. A lot of interest in this bill, and I understand why. In the first winter after I got this job, I was at our caucus retreat actually in one of the committee rooms here, and there was a school shooting at that time when we were having our caucus retreat. I remember us stopping and praying and then moving on with things. We didn't spend a lot of time talking about it. There wasn't any legislative action on that. Not that I recall, certainly in that following session. In the intervening 11 years, there have been a number of shootings, awful acts around the country. And they all get our attention for a few days. They don't seem to last beyond a few days or maybe a couple of weeks, unless you've been touched by that directly, as Whitney has been, and she'll talk about that. But that changed for me last May of 22, the day of the Uvalde shooting. It wasn't substantially different from the other shootings that we've seen in schools in particular, but it bothered me in ways other awful acts that we've seen, mass shooting events that we've seen didn't. And it bothered me because the little boys and girls that we were seeing stories about, or that we saw were killed, or we heard calls from, or pleas from, read stories about, were the age of my kids. And it really bothered me. It bothered me then. It continues to bother me today. And I felt compelled to try to come up with a solution. That day I opened up a bill request for a car. Didn't file it this year, but I've continued to work on some version of this bill, crisis aversion and rights retention. There are a number of other states around the country that have done something similar to this, but I tried to make it different. I tried as a Second Amendment supporter, as a gun owner, former NRA member. I wanted to make sure that it was constitutionally sound. And so I set out to try to do that and come up with a version of this bill that didn't present some of the same problems that prior attempts at this, not only in Kentucky, but in other states, has done. I believe there is a continuum of Kentuckians, so to speak. Everyone agrees law-abiding citizens ought to have firearms. The Second Amendment guarantees it. Everyone generally agrees, though I think there might be members of this body or the legislature broadly that might quibble over certain specific examples, but I think generally there's broad agreement that felons don't have that right anymore. At least there's no rushing of the door of our colleagues, all of us, filing bills to allow felons to have those guns again. So I think there's broad consensus that there's that category on the other end of this continuum. And there are already instances where under law in Kentucky and around every other state in the country, we already pull guns and remove guns on a temporary basis from people that are in domestic violence situations. Though, admittedly, there's a case that the U.S. Supreme Court right now is considering, the Rahimi case. Oral arguments were about a month ago. That might change that, might not change that. But there are already some instances where, on a temporary basis, firearms can be removed from somebody if they pose a sufficient threat. What I'm trying to do is to identify best I can, and I don't claim to have a perfect solution here. I'm going to give you some details of two different drafts or versions of this. You don't have them in front of you because it's subject to change a lot. But I hope to get your feedback and input and tell me where I've screwed this up or where I can make it better. And for some of you, if it's okay, it's okay if it's never going to get somewhere you're comfortable with. That's fine too. But I feel compelled to try. And I feel like it's my obligation. And though I can't speak for you, I believe it is your obligation to not be afraid to have difficult conversations about the toughest issues that people of Kentucky face. And this is a tough one. And we were reminded of that just this April. Or March, I'm sorry, I'm drawing the blank on the date of the bank shooting. Thank you. So, two versions of this. Keeping in mind that the vast majority of the shooters involved, there's some data that suggests about 87.5% of the shooters, not all of whom survive, obviously, so this is based on those who did survive, but 87.5% of the shooters in these mass incidents. And we're also going to talk about suicide quite a bit this morning, but the vast majority of those people are struggling with either misdiagnosed, undiagnosed, or untreated behavioral health or mental health issues, trauma of some kind, PTSD even. There are instances where, and we've seen even in the most recent shootings, cases where people knew the shooter was struggling with this. In fact, if you have a criticism of these bills around the country, one of the criticisms is that they're underutilized in the states that still have them. And if Kentucky ever were to enact something like this, we can't make that same mistake. So I set out to have a new version. One of the biggest objections is the ex parte hearing, right? You want to have due process of law and protections there. The Second Amendment guarantees a right. If you're not a convicted felon, we generally agree that you should be able to have a gun. And the ex parte hearing creates some problems for folks, and I understand why. And so we set out to try to find a way to do this without having an ex parte hearing. So the version that I've shopped around to a handful of people, some of whom like where I'm going, and some people hate where I'm going, and some people have practical concerns about it. But I'm going to give you that description and how that turned into the second version. I'll talk about that as well. There is no ex parte hearing. Instead of having an ex parte hearing, for those of you not familiar, in these bills around the country, the petitioner can seek an order from the court, and the court reviews that. The court reviews that on their own without the respondent or the gun owner in the room. And if they find it's compelling enough, it meets the standards, they issue an order, temporary. Law enforcement exercises that order or enforces that order, collects the guns. And then there's a hearing a week or two later. That initial review without a hearing creates a lot of concern for people. So I wanted to come up with a way that didn't have that step. What we came up with is having that petition, and I'll point an important distinction between ours and a lot of other states. You can't just anybody go and get this petition and ask a court. You got to convince a law enforcement official, an officer, to petition the court. And in this particular case, that individual can petition law enforcement. The law enforcement then, instead of going to court, goes directly to the respondent and gives them an option. And there are some protections and controls about when you can do this. You can't do it in the middle of the night, that sort of thing. But it gives the respondent the option. You can have a hearing within X number of hours near immediate. Keep your guns until then, not keep your guns, that's up in the air. Or you can give us your guns now, and we'll have a hearing in a week. And again, the time periods in there are changeable and adjustable. The burden is on the respondent in that particular case to make sure that and the standard in the current draft I have is probable cause, but there are other versions that we've tried beyond reasonable doubt, which is something people have asked for in the past. It is a standard somewhat less than the standard for involuntary commitment under 202A, because if you've met that standard, then you need to be involuntarily committed under 202A, which also deprives you of your rights to your firearms for at least 72 hours. But the respondent has the burden of defending that in that particular case. But at least they've been given a chance right there at the moment to have a hearing within, and the draft I've circulated, and there's some judges behind me that have read it. I had 2 hours. You can have a hearing in 2 hours, or give us your guns and we'll hold them for the week, and you have a hearing, a full-blown hearing in a week. There are some practical problems with 2 hours. If you're a district judge or riding a 4-county circuit, 2 hours might not be tenable, though I think remote attendance might be an option to solve a lot of those problems. But judges that have seen this have reached out and said that presents an issue. And so I came up with a second version. If that's not realistic, and again, I'll tell you the problem with it is that if you tell someone that you fear has got a mental health issue or a trauma, something that you're worried they're about to break, and then you don't act with some near immediacy, you might actually provoke the act. That's the concern. And you're balancing that risk and that concern with the Second Amendment right that they have. And no one disputes that they have. So that's first option. Option two, we do bring the ex parte hearing back in for this option, this particular path, that this is the way that there is more support for. But something that is in this bill that has not been in any prior bill, and I'm not familiar with I think there are 19 or 20 other states that have something like this. I don't know if another state has it. But this follows the 202A schedule and protocol. So all the district judges are familiar with that. It's a near immediate review of the petition. It still has the law enforcement step, so it's not just anybody on a whim asking for a judge to get your guns. There has to be some articulated, specific reasons for the basis for the order. But with this ex parte hearing and following the 6-day or 5 or 6 day protocol under 202A, this would be 202D. Someone suggested 202G for gun. I don't know if the statute revisers would let us do that, since D is the next one, but put under that statute enforcing the fact that the mental health response is the key here. That's the whole point. And I'll remind you, and I'm going to read it. This is from Heller. Justice Scalia, beloved by Republicans, and people that are paying attention to this issue already know this line from the case. Like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. For example, concealed weapons prohibitions have been upheld under the amendments and so on. The court's opinion should not be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill. And that's a summation of language that appears in the opinion. But we should be able to identify that and come up with some solution to respect the Second Amendment rights while still protecting that individual from themselves or from the harm of others from that person. In this particular case, the unique thing is the presumption that the guns should be returned. It's rebuttable, but the presumption, the default position is that the guns be returned to that respondent, or that the guns not be taken from the respondent in the first place. And then on every subsequent review, the presumption is, and that puts the burden on the petitioner. Whether it's law enforcement or someone else on their behalf and their witnesses, they have to show each and every time it's reviewed that that's the action. Those are the two proposals I've got. I'm going to let my other witnesses speak, and I've gone longer than I aim to, but I wanted to highlight that. And the reason you don't have a bill draft, apart from the fact that there are these two versions that are very fluid, we've made a slew of changes. I expect I'm going to get a lot of questions and feedback today about things that need to be changed and altered further. I do plan to file the bill, and when I do, I want to have your feedback and your criticisms factored in. Would.
Chair Elliott and Westerfield and members of the judiciary, thank you. I am truly grateful to have this opportunity to discuss a solution for preventing crisis moments, crisis aversion, and rights retention. While my voice is just one, please know it represents thousands of Kentuckians who subscribe to the Whitney Strong approach to reducing gun death and injury in this state. The voices of many, some of whom are here today, and others who could not join us, like Mac Brown, Dr. Sheila Schuster, and Missy Jenkins Smith. Their statements and those of others lending support to this effort are in your packets. Collectively, we all believe in making communities safer through respectful dialogue, following the data, love for one another, and seeking common ground. Collectively, we know it is important to understand what CAR is, just as it is to understand what it is not before deciding what is right for Kentucky. To begin, I want to start with our collective desire to protect innocent life. As a gun owner leading my organization that represents a very diverse supporter base, I know every day from conversations that gun owners and non-gun owners alike, Republicans and Democrats, we all align on this foundational value. And on September 6, 2018, I saw this shared value collapse, and to the detriment of myself and thousands of other people in Cincinnati, Ohio. On that day, I faced something that I can only describe as hell on earth. As I walked into the corporate headquarters of Fifth Third Bank, I found myself stranded in a revolving door, taking gunfire from a severely mentally ill man who was in lawful possession of a firearm. For one agonizing minute, I lay there helpless as 12 bullets entered my body, coughing up blood and trying as hard as possible to remain lifeless for fear that he would fire the next round into my body. And while that was happening, all I could think about were my precious children and my husband, and begging God that I would live to see them again. Now I just want you to take 1 minute, a second, think about those you love most, and think about that trauma being inflicted upon them. Think about your innocent spouse, your parent, your friend, or God forbid, your child. I am telling you, there is nothing that you wouldn't do to prevent them from experiencing this. The collective, or our shared humanity, I believe, calls on us to prevent this violence. It calls on us to reconcile the role we have all played in allowing these incidents of mass violence to play out unrestricted. Sorry, 1 second. It calls on us to carefully and thoughtfully consider why. Why, despite the all too frequent misuse of firearms we see going on around us, we recoil at the prospect of change, why we recoil at the prospect of taking clear steps to help gun owners before they misuse their guns, or at the opportunity to do what is right for Kentuckians, gun owners, and non-gun owners alike. Since 2018, I have traveled a long road of trauma, and along the way, I have met far too many others who have been forced to travel this path with me, some of whom are very bravely here today, and I want to recognize them. We must lift up my friends Marianne Elliott, who's right behind me, Jeff Derrick, who's to my right, and then Karen and Andrew Tutt, who are right behind me. Here's the date. It was April 10th, 2023, that their loved ones were brutally murdered in a mass shooting at Old National Bank. The shooter, while mentally ill, was in lawful possession of a firearm. We must also lift up my very brave friend, Kirsten Russell, who's here today. On April 23rd, 2018, Ruth, her mother, was viciously murdered by her mentally ill son in her own home. Her family had sought a mental inquest warrant, but it was denied. Just like the rest of us, he was in lawful possession of a firearm. We must lift up the many other brave Kentuckians who are here with us today who have lost loved ones to suicide by firearm, domestic violence involving firearms, and more. In our shared humanity, it is time that we lift up those who paid the price for our collective inability to solve for this problem. It is time for those, perhaps some in this room, with the tendency to say no or never, even before fully understanding all of the options, to think about how we, the collective, can help save those innocent lives, help gun owners and those around them, and help before these crisis moments turn into tragedy. It is time. Let us solve this problem together, and let's start first with the data. For the most recent year on record from the CDC, which was 2021, there were 947 gun deaths in this state. This is an average of one person killed every 9 hours, and that included 93 of our children and our teens. And a majority of Kentucky gun deaths, which people don't realize, 56% were suicide. That represents 534 lives. Gun violence has only increased in our great state in the last decade. From 2012 to 2021, the gun death rate increased 43%. And you can see the division here between firearm suicide and firearm homicides. Now let's talk about homicides. In 2021, 89% of homicides were completed with a gun. Homicide with a firearm impacts males at a rate that is 5 times greater than females, Black people at a rate that is 14 times greater than white people, and urban areas at a rate that is 2 times higher than rural areas. Also notable, there have been 8 incidents of mass violence in our state just this year. That means 4 more people injured in a public place, 1 in Lexington, 1 in Paducah, and 6 in Louisville. And then I want you to really look at that heat map to the left, because suicide tells an entirely different story in our state. In 2021, 65% of all suicides were completed with a firearm. Suicides by firearm impacts males at a rate that is 8 times greater than females, rural areas at a rate that is 1.4 times higher than urban areas, and the populations with disproportionate impact include white males, veterans, farmers, and minors. And while the narratives surrounding gun deaths in our state are often tied to urban areas, the 3 counties with the highest gun death rates from 2011 to 2020 were all in eastern Kentucky: Wolf, Knott, and Lee, largely driven by suicide. So what is the problem? As a supporter of the Second Amendment and the executive director of an organization that includes many gun owners, let me start with what it isn't. We know the misuse of firearms is not tied to law-abiding, mentally well gun owners. CAR was not created for them. CAR was created to surgically identify the small subset of gun owners, including those in lawful possession of a firearm, who are on the brink of misusing their guns to harm themselves or others. When faced with this current scenario, authorities have no legal path. Let me say that again. There is nothing today, no legal path to press pause and temporarily transfer those firearms away from the person and finally put them on a path to rehabilitation, all the while preserving their right to go on to continue to own that firearm. CAR is the solution to this problem. It protects innocent life by preventing crisis moments with guns. It is a helping tool. It is designed to get gun owners back to a place in which gun ownership is safe, and it protects the individual Second Amendment rights by hitting the pause button long enough to get them the help that they need. Let us focus our energy on preventing the next mass shooting in our state, or on gun owners who need our help. Gun owners who are struggling with suicidal thoughts, or on gun owners buckling under the weight of this world and considering choices that they would otherwise never make. Perhaps some of you or some of us in the room know such a gun owner. Why wouldn't you want to help them? Thank you.
Good morning. As I said, I'm Rick Sanders. I'm currently the Chief of Police in Jeffersontown, Kentucky. Many of you in this room I know, but some I don't. So I think it's important for you to know who I am and why I'm here. I have been in law enforcement for 4 decades. I've been in federal law enforcement, state, and local. I began my career in the 70s as a young police officer, 20 years old, on Dixie Highway. I have seen trauma. It's not anecdotal. It's not something I've read out of a book. It's what I know. We've come a long way in law enforcement. We're much more professional today than we were back in the 70s. We have many more tools to use in helping us do our job. But we're faced with things today that I have never seen before. And one of the biggest problems we face in law enforcement is people suffering from mental illness. I'm going to I've got pages of things I could talk about, but I'm just going to use a couple of examples of why I'm so passionate about what I talked about this morning. I'm a Second Amendment advocate. I've got a safe full of guns in my house. But I also recognize that there are people suffering from mental illness that shouldn't have access to a weapon. And I'll use another analogy. When my uncle was suffering from dementia, I took his keys away from him. It wasn't the car's problem, it was his problem. He was suffering from mental illness. And I think it's much the same way when we talk about what we're talking about today. This is not a gun problem. This is a mental health issue, and we have to address it. On January 23rd, 2018 at 8:57 a.m., my executive assistant walked into my office. At the time, I was commissioner of the Kentucky State Police. She said, "Commissioner, we have an active shooter situation over near Benton, Kentucky at the Marshall County High School, and there are casualties." The governor and I boarded an airplane and flew to Marshall County and went to the school. And when I walked in, I saw 15-year-old Bailey Holt laying on the floor dead. I saw backpacks, phones, shoes of students that had lived through this ordeal and had been facing this challenge. The shooter was a 15-year-old student at that school who suffered from mental illness. And I think when I saw that, I thought, there are doers and there are talkers. And I want to be a doer. We have to do something to stop some of this. There were 2 people killed that day. There were 14 people totally that have been shot, 18 injured in all. He was taken into custody and by a sheriff in Marshall County. And although the SRO did not stop the shooting, I believe he stopped the continuation of the shooting by being in that school. This young man, who I won't mention his name, after shooting all these people, threw the gun down and tried to blend in with other students, that he was apprehended by the sheriff. That young man had taken a gun from his stepfather and had committed this heinous act. He's now serving 2 life sentences, but that doesn't bring the life back to Bailey Holt and Preston Cope. Preston was a young man that was taken to Vanderbilt Hospital and subsequently perished from his injuries. The governor and I actually stood in the home of the Copes and prayed with them and cried with them and grieved with them about what had just happened. That's why I'm here today, not to take guns away from law-abiding citizens. I will advocate for the Second Amendment from now on. But there are some people that are in a condition of mental illness that should not possess a gun. And I think we need to work this bill through. I started talking about this 1.5 years ago when Senators Paul Hornback and Morgan McGarvey, a Democrat and a Republican, came to my office with Whitney and said, "Chief, can you help us? We've been talking about this for that long." And my good friend, Senator Westerfield, thank you for having the courage to bring this forward today. This is not an end product, but this is something what we're bringing to the table to talk about to try to save lives. And that's what the purpose of this bill is. I can also talk about when I was a young police officer out on Dixie Highway, I had a suicidal subject who had a gun. I was young and full of it back then. And I sat across from him and watched him as he talked about committing suicide. And then I saw him shoot himself in the mouth. Needless to say, I did not become a hostage negotiator after that. But, the sadness that I saw from someone suffering from mental illness that took his own life in front of me has stayed with me for the years. Again, my family is 4 generations law enforcement. We're all gun owners. We're all avid shooters. And I'll go to the range with any of you that are law-abiding citizens. But there are some people that have shown that they're suffering, and we need to take the firearm away from them before they can hurt themselves or others. In 2015, we faced an opioid crisis in J-Town. We thought outside the box. We started an angel program where we invited people to come in and the police would help them get assistance. People thought I was crazy for doing that. We have now helped over 3,000 people that have substance abuse disorders, which is another form of mental illness. So we can't sit back and say, nope, never going to happen. We got to work on this. We've got to get together, Democrats, Republicans, independents, and talk about how we can fix this. I know there's another bill coming up right after us, and I could testify on that one as well. Anybody that knows me knows that I'm a law and order guy. I'm unapologetic for locking up bad guys. But we've also got to think outside the box and try to keep people from killing people like my comrade or my partner, Officer Nick Will, who was shot in the head in a bank in Louisville a few months ago by someone suffering from mental illness. We have got to do this. And I commend Whitney, both Whitneys, for having the courage to bring it before you today. Thank you.
I'm Steve Shannon. I'm with the Association of Community Mental Health Centers. This is a serious issue. And I think the mental illness piece for me is an acute episode of mental illness for many people. And at that point, they need treatment. Okay. I'm going to tell you the truth. It's not a secret. My members don't like me talking candidly. We have been profoundly underfunded for a long time. Right, Senator Westerfield? Yes, sir. Profoundly. I would love to tell you we can address all these problems on the spot. That would be disingenuous and dishonest of me to do so. We have tools. Kentucky has current statute for involuntary treatment. You heard about 202A. That's an involuntary hospitalization for 72 hours. But you got to know about the person. The process has to start. There has to be, and it's due process, but it has to be initiated, and the person has to meet the need for hospitalization. Not everybody meets that need. The situation earlier, they probably didn't meet that need for hospitalization, so they didn't go to the hospital. And if they do go, 72 hours. You can extend it, but it's 72 hours initially. It's involuntary treatment. There's court-ordered outpatient treatment. I think Judge Burke is here somewhere. She's a champion of court-ordered outpatient treatment. But again, it's court-ordered, it's involuntary. The person has to have a history of not participating in treatment. They have to be known to the system. They have to be aware. They were supposed to go, take their medicine, go to therapy, and they didn't. Part of what I want to talk about are those folks who we don't know about. And a lot of those people are untreated mental illness. And when I think mental illness, what comes to my mind, the visual, is a person in my neighborhood who was homeless. And I live downtown Lexington. My daughters, as young children, knew if it's summertime and they're wearing a parka, that person's not taking their medicine. Wintertime and wearing shorts, that person's not taking their medicine. My daughters could do that at a young age as an indication. We're talking about other folks who are in acute mental health crisis, whatever it might be. Might mean they got a call from their spouse saying, I want a divorce. And they take action. This is a true story. They take action. They leave work. I'm getting out of here. Co-workers thought, I'm leaving work today. The individual saying, I'm getting out of here. Went to Walmart to purchase a handgun. Said to the sales clerk, I'm going to go home and kill myself. Sales clerk called the police. It didn't happen. Access was denied at that point. Not forever. At that point, access was denied. Another story, an individual, after their junior year of college, had a tough summer. Junior year wasn't great. They went home for a while and stayed in their room. Eventually hospitalized, but stayed in their room. Person graduated college, was the best man at a wedding. 2 people called him uncle. He cared for his aging mother. It's my good friend Howie. He was my college roommate. He didn't have access. He didn't have access. Therefore, a bad thing was averted. CAR is a prevention tool. It's not a treatment tool. Prevention is an evidence-based practice. Prevention works. This is what CAR is, prevention, maybe early intervention. Let's not have a bad thing take place. Let's have someone, a family member, bystander. This person needs help, and take that action and temporarily remove firearms. For me, it's temporarily remove firearms. Suspending. I'm not a gun owner. I've read the Second Amendment. I have no problem with gun ownership. My good friend Howie is a gun owner now. But sometimes folks need to be protected from themselves, and that protects themselves and others. And CAR's about preventing bad things from taking place. Are we going to get to zero? No, we're not going to get to zero. 85 to 90% of suicide attempts with a firearm are fatal. 85 to 90%. 55% of men use a handgun, a firearm, when they commit suicide. 30% of women. Now, number one, we need to do something about this. We need to say, let's figure out how we can move forward. I don't have the compelling stories that my friends have. I admire Senator Westerfield for bringing this on. Long history. I knew his dad before I knew him. A long history of what can we do to make lives better for people. We need to take action to say, let's stop this now. We passed the law 202C recently to make sure people who couldn't participate in their defense remained in a forensic psychiatric unit. Didn't have that before. People were released, right, Representative Amos? We changed that. We changed that. Let's move forward and say, for now, Steve, we're going to ask voluntarily, right? But we're going to have a mechanism to take your weapons away for your safety and the safety of others. So things don't happen. A mental health center in this state has responded to 2 school shootings. I don't think there's another one in the country that's responded to 2 school shootings. I've been at CARP, I'm in my 27th year. My first CARP meeting was the month after the Heath High School shooting. We spent the whole day talking about the response then. I learned the value of community at that point. That's what taught me about it. But showed up at school, bad thing happened, no one took action. This creates a mechanism for someone to say, let's hit the pause button and move forward. And the pause button will be best. CAR is prevention. Prevention works. Let's not have bad things happening when we know what they are, potentially, and remove those things. Thank you.
We'll take your questions, Chairman.
Thank you.
To the extent time permits.
Thank you, Senator Co-Chair Westerfield. Thank you, Ms. Austin, for your story. I know we met, and you have a miraculous story, and I admire your courage. Senator Westerfield, I have a question, and you referenced the 202A law as it currently stands, MDO or MDW. Why isn't that sufficient to take an individual's access to firearms when they're experiencing this mental health crisis? Why? What is the flaw as the law currently stands?
It's a great question. I don't think it's a flaw as much as an inadequacy, or in some instances, more than you need. You heard the story about someone seeking a 202A commitment and it was denied. I think there's a universe of people who present with a severe enough issue that we should hit this pause button and just let's make sure everything's okay, maybe get some help that you need, but you don't need to be involuntarily committed. Not only that, but it's only if you wanted to commit them, and I don't know that everybody on this committee would, it's only for 72 hours. It can be extended. So in some instances, it's more than you need. In some instances, it's not as long as you might need for someone who is more severe. I think depending on the fact pattern you might have, I think there's an intermediate step that we should explore. That's what this presents.
And I'm not going to hog the time. I know we have a lot of members who have comments and questions. I'm going to recognize Representative Maddox.
Thank you, Mr. Chairman. Senator Westerfield, my long-standing opposition to this proposal is known to you. It's known to my colleagues, and in all likelihood, it's known to most of the folks in this room, so I'm going to keep my remarks brief. The value that I know that we all share, everyone who's gathered here today, is a sincere desire to keep Kentuckians out of harm's way, an earnest desire to prevent the unthinkable. However, we strongly differ on the premise, I feel like. Gun control is not and has never been the answer. Whether you call it a red flag, whether you call it an ERPO, whether you call it CAR, or any other euphemism, you're still talking about a proposal that at a bare minimum has the potential to violate at least 3 constitutional rights, in addition to due process and the presumption of innocence, which is a principle that is deeply enshrined in our American legal system. Leading up to this hearing, I have heard quite a bit about finding common ground. I respect that rationale. I understand it. But to me, our common ground is the Constitution. We've all sworn an oath to uphold it. And regardless of our differences of opinion, that's what we have to do. Now, there is little merit in debating the technical issues that may arise from this proposal, but one aspect in particular of any red flag proposal that I have always taken issue with is in terms of seizure. If you have a situation where you have multiple folks that are dwelling in the same household and a red flag is called in, when law enforcement comes to seize the firearms, do they automatically know where to find them? Are they told where to find them? Do they dig through the entirety of the house? Do they saw into the safe? Do they dig through the barns? Do they dig through the cars? Do they tear apart the Fourth Amendment in the process? I think the question then leads to where we would be in potentially a scenario to have a foot in the door for a registry. And it's also important to note that there are other folks in that household that are not implicated at all in any of this, that have the ability to have their Second Amendment rights infringed upon. So knowing that we already have a system in place that can get folks who are experiencing an acute mental health crisis access to treatment immediately, removing them from that dangerous situation instead of infringing upon our Second Amendment rights, I think that's worthy of noting. I also think, bearing in mind this value that I spoke of, the value of we all want to keep Kentuckians out of harm's way, lawmakers must seriously consider the fact that 94% of mass casualty tragedies occur in so-called gun-free zones. These are places that law-abiding citizens have been stripped of their God-given, constitutionally protected right to defend themselves. And that is precisely why these locations are chosen by those who seek to harm and destroy others. So often, we are told that we must do something. Yes, we must do something. We must fervently resist any effort to pass gun control legislation, and we must be serious about analyzing the data and putting a stop to these ineffective policies that put innocent citizens in harm's way. And we have to encourage privately held entities to do the same. That's the extent of my remarks. I appreciate your remarks and, Mr. Chairman, the opportunity to speak.
Thank you, Representative Nemus.
Thank you, Mr. Chairman. We've talked a number of times, Whitney and everyone else at the table. I want to thank you guys for coming here. I know it's not easy to do. I've talked about this bill a lot with a lot of my constituents on all sides of this issue. I don't know that there are just two sides of the issue. I'm going to ask the other side the hardest question I can come up with as well, or one that gives me pause, but I'm going to ask the same of you on the other side, which is the biggest concern I have with this bill. So I'm going to try to be a lawyer and kick the tires on both sides if I could. I think the biggest problem I have with this bill, and thank you for having the hearing, I think that's important in the due process, but fundamentally, this bill takes away a constitutional right from a citizen based on the prediction that they might commit a crime in the future. And so we've heard today that could be indefinite. It's not just the 72 hours, it could be forever if the judge continues to have that and there continues to be hearings. And so while I understand that the purpose of that or the intent behind that, it seems to me that's a problem. So what do you say to those who say it's a little Minority Report? I know a lot of us have watched that movie. This person has done nothing wrong. They have not committed a crime. They don't have a history of a crime. They've done nothing wrong. And we are taking their constitutional rights away, perhaps indefinitely. What do you say to that?
It's a good question. The system we have right now limits your constitutional rights or your liberties already based on probable cause. When you're arrested for a crime, you're not guilty of that crime yet. You're presumed innocent. And by the way, this doesn't change anything about the presumption of innocence. This is not a criminal proceeding. This bill doesn't propose any criminal penalty. There's no change to the presumption of innocence. There is no criminal act at all. It can't be used against you in some sort of subsequent case. No change or alteration to that at all, or even an attempt to do that. But there are limitations even on other bedrock constitutional rights. Would you agree with that, Representative Amos? There are already restrictions on, say, Fourth Amendment. I have a Fourth Amendment right to privacy to my person, my car, and my house, but not to your house, and maybe not even to my yard, depending on the facts of a certain case. There's limits to that. I think there ought to be some reasonable, very, very carefully drafted limits to this. And only because of the people that we've talked about today. Not you and not me. I hope, I pray, not ever. Either of us or people like us and the rest of us that are law-abiding and mentally well, as Whitney said. But we've seen instance after instance after instance after instance after instance of someone who is not mentally well, who was, until the moment they snapped and did publicly what they were thinking about and conceiving of doing, lawfully possessed the firearm. I think and again, I can't speak for any of you, but if you knew that the shooter at the bank in Louisville in April was going to go and shoot all those people, if you knew in advance, I don't think anybody in here would arm him. Do we have to make some best guess based on a list of factors, based on concerns raised by people who know that individual? That's the best that we've got. If you got a different solution, man, I'm all ears. The law has to allow us to protect people in a way that honors the Constitution, but protects people at the same time. It's not an unlimited right. It's just not. And neither are the other constitutional rights. There are limits and lines drawn for all of them. We got to figure out where the line needs to be drawn here. And I don't have the perfect solution to that. But we need to talk about where that line ought to be. That's the best answer I got, Representative.
Thank you, Mr. Chairman.
Thank you, Senator Burke.
Thank you, Mr. Chairman. Thank you guys for bringing this forward today. I'm going to try to make my remarks brief because I don't honestly have a question. Many of you all know it was actually a year ago this morning that I woke up to the phone call that my child had ended his own life. And as a result, on Thursday evenings, I go to a group, Survivors of Suicide. And it's the only thing, honestly, that has kept me sane over this last year. But every Thursday night, I sit there and cry with family members, every one of them, with the exception of me. And I thank God every day, I thank God that my child did not put a gun to his head, and God forbid, did not go out and kill somebody else with his suicide, because that's what most of these school shootings are. They're public suicides. But I sit and I listen to these parents. The youngest one in my group is 14 years old. Describe what it is like to watch your child blow their head off. And it is unfathomable. And if we could do one thing in this state to prevent one parent from having to go through that, it is worth it. Because this is hell. This is hell. I cannot explain to you. To sit there and watch your father say, I cannot see anything else. I cannot see anything else. And people try to say eventually it'll go away. Eventually it'll get a little better. It'll get a little softer. Guys, we are talking about a mental health crisis. A crisis of a proportion that we have never seen. And without acting, we are letting our children kill themselves. You know, one of the mothers last night, her son was a schizophrenic, a known schizophrenic, a diagnosed schizophrenic. Somehow he was able to buy 3 guns without her ever being aware. And she's like, how could that happen? I mean, not only was he a schizophrenic, she said, he looked like he had a mental illness. Like anybody who met him would know something's not right. And still he was able to buy 3 guns in this state and kill himself with it. Thank you.
Representative Rawlings.
About the subjectivity of all of this, and also that the process becomes the punishment. Back into court or whatnot that are they're innocent. And I thought criminal law, you have elements of murder, there's certain elements, there's something to tangible to go to. But in this case, what did these people do? What is the crime? What is the upfront crime? I think it's going to target a lot of people groups, like people in rural areas, good old boy networks. It's going to target veterans, could target inner city blacks. It could target people within the home, aside from the main target. It could be a problem with who are the petitioners, who are the accusers, what expertise do they have? Do they have psychology degrees? Can they psychoanalyze? You have so much corruption, and I have a real concern with judges right now that don't all rule constitutionally. And so you have decision makers and judges that may be dealing with ideological concerns. They deal based on their own ideology or their personal policy preferences. So I don't trust the system right now for engaging in these type of issues.
I appreciate that, and all of that's most of that well taken, and I appreciate the comments. But we rely on the system to get it right now. We rely on the judges to exercise their judgment well today. We rely on prosecutors, and we trust them to exercise their discretion well. We rely on the system to capture the people that are guilty and convict them. We trust the system to render not guilty verdicts for those that are innocent. It gets it right more often than not. I can't guarantee you, and no one could, that any part of this or any other bill any of us might file or pass would be followed exactly the way we hoped and intend, because that's just not going to be the case. You're going to have judges somewhere that do this right. You're going to have judges somewhere that abuse it, I'm sure. Thankfully, we have appeals for that. We have challenges for that. We are talking about a constitutional right, but we're not talking. Cheating has a quite a bit higher burden and a much stiffer sort of penalty for things that when people break the law. But in this, it's a civil process and it's a temporary thing. And again, I'm open to any suggestions you've got to increase those protections. And for fraudulent or bogus claims or petitions, right now, the version that I have, both of them include just household members or immediate kin. But I think it should be coworkers. It should be somebody else. If Amanda doesn't know that I'm struggling with something, but one of you do, God, I hope you say something to somebody and get me the help that I need. The folks, and y'all tell me if I'm wrong, but I think it was the shooter in Lewiston in Maine, where coworkers said we knew that he got help or maybe needed help. I think it should be it can't be wide open. But if by the way, the language, and I think the language even in Morgan and Paul's bill included protections for doing this fraudulently. And we already have criminal offenses for fraud and deceit. But if there are additional protections to protect against someone filing a bogus petition or seeking a bogus petition, please tell me what they should be, and let's throw them in. It's not going to be bulletproof, pardon the analogy, but let's make it as safe as we can, because it is a constitutional right we're talking about.
Thank you, Senator. We have several more members who
Sure,
have signed up to speak, and we've been here about an hour, so
We've
I'm
maxed
going
out
to
time.
try to recognize a few more of them if possible. And I would just ask you to keep your comments or questions very succinct. Representative Burke.
Thank you, Mr. Chairman. Senator Westerfield, Ms. Austin, and all of the panelists, thank you. From the bottom of my heart, thank you for what you've done today in bringing this before the committee. For me, the value of this bill is in the sphere of preventing suicides. After an acute mental health crisis in college, I attempted suicide. By the grace of God, I lived. If I had tried with a firearm, I would not be here today. I would not have my family. I have a lot of friends who didn't have this outcome. I've lost a lot of people to suicide. Presently, I spend a lot of my time working with veterans. And just last week, I met a veteran who recently attempted suicide with a firearm. And by the grace of God, he only lost his eye. What he gained was a lease on life. And I have never seen someone more invigorated than that man, who is now working on his mental health and getting back on his feet. I've heard a lot about deprivation of liberty today. And when it comes down to it, we are looking at two different types of deprivation of liberty. Are we going to put people into mental institutions against their will, fully depriving them of the ability to be in their community among their loved ones? Or are we going to deprive them of access to their firearm for a brief time so they can get it back together? To me, that's what love requires. Love requires reducing risks without putting someone into an institution. Senator Westerfield, I'd ask that you please consider marrying your proposal. By the way, I like version 2 better, but I would work with you on version 1. I've been working on a bill to trigger, no pun intended, this type of work through the 202A petition. So if a 202A petition is not granted, would you consider allowing that to be a method by which this process could unfold?
I've actually thought about this as sort of a second, like an off exit ramp, short of commitment this. So that has been something I've considered. So I certainly would. Thank you.
Thank you very much.
Representative Flannery.
Thank you, Mr. Chairman. 2 questions, please.
Just one.
One. All right.
You can ask me the second one after.
That sounds good. So in listening to your all's testimony, there seems to be this notion that when someone is suffering from an acute mental health episode, that the judicial branch of government can, in real time, prevent someone from harming themselves or others. And so taking out the constitutional concerns that I agree with, that Representative Maddox discussed, Representative Nemus discussed, I'm trying to figure out how you're supposed to stop someone from hurting themselves or others in real time. It's going through an acute mental health episode. I just don't see how that's possible.
It's easier with option 2 than option 1. The ex parte hearing that is so contentious because it's ex parte, that means that respondent's not there for that initial at the petition and entering a temporary order. The benefit of that, as I mentioned before, is that that person doesn't know that, and so they're not acting, and you pray that you stop them in time from doing something horrendous or horrific. Potential that you don't stop it, to be perfectly blunt. If you inform them, you go, if there's not an initial ex parte and give them that option, a hearing in a few hours or a hearing in 2 weeks or in a week, and they choose that option, the latter option, there's absolutely nothing stopping them from lying to you about the guns that they have. Sure, I'll turn over the 5 I want you to have, but I'm going to keep the 6th. And there's no search, Representative Maddox, or ransacking of a home or anything. I think it's on the honor system. Hide a gun, or if they go and get a gun, and the bill does actually speak to them doing that, which is a violation. To approach them and when that hearing is. It's why the ex parte hearing is so valuable in the states that have that, or in option 2, as I've talked about. Yes, ma'am, please.
Thank you, Representative Herring.
Thank you, Chairman, and thank you all for your testimony on this super complex issue. Some of the things that came up for me is I was 17 years old, a senior in high school when Heath High School happened, and had not thought about that until you mentioned it. And that's a lot that we are still battling and trying to figure out solutions. Some of the other things that I heard during the testimony was that we need more funding for our mental health centers. Also, I heard a lot about the mass shooting at Old National Bank. For the record, for those who don't remember or know, also 7 days later in Louisville, there was another mass shooting in Chickasaw Park, which is in my district. And so I say that to say that whether it's a legal gun or an illegal gun, it's not normal for people to shoot and kill. It's going to take a lot for us to address and fix this issue that we're dealing with. I think that it's going to take many tools. I think that this is one potential avenue to get that done. But I do think that we have to take a public health approach. And I think that when we've heard the testimony, that's what we continue to hear: public health, public health, public health. And so I just want my colleagues to know, as we're moving forward and as we come into January, to think about all the different things. Even if we were to pass this bill, this is not going to be enough to address the issues that we're seeing in our communities.
I hate to
But I
cut
do
you
have,
off here,
I have
but
one, hold on, I have
I
one
want you to
question.
keep it concise.
I have heard that people say that CAR is a red flag law. Can you all just kind of verify and talk about how this is not necessarily a red flag law?
It bears a resemblance to those other states. If people want to call it that, I guess help yourself. But it's meaningfully different in a couple of ways. First of all, the timelines are shorter. The burden of proof is going to be higher, at least in the draft that I have. Burden of proof is higher than what is typical in other states. If it's option 1, there's another state that has something like that avoids the ex parte hearing altogether. That is a substantial difference from any of the other bills. What else am I missing? Oh, and then who can petition? So we talked about that already. There's not just anybody can just go and ask a judge for this. You've got to convince law enforcement officer that this is warranted, and then they've got to convince a judge if it's option 2, or they've got to at some point convince a judge. But it still has that law enforcement step. Now, 202A proceeding has a mental health expert that's got to sign off on that. And I wouldn't have a problem with that at all. But then you reintroduce the problem that they are now informed that something's coming, and they can act on whatever their targets are. So again, those are the things you're balancing. So I don't have a problem with that adding additional steps, but ours is one of the states, if we were to ever pass this, it has that law enforcement step, and a lot of states don't.
Thank you,
Don't
Senator
forget anything
Storm. I'm going to give you 1 minute to ask your question or your comment.
Thank you, Mr. Chairman. Very quickly, you quoted a Heller 2008 Supreme Court case, correct?
Yes, sir. To be accurate, I quoted the syllabus, which is a combination of a couple of parts on page 54 of the Heller opinion, where Scalia still writes what those things that I talked about.
Thank you. So again, I greatly appreciate you. I cherish your friendship and
But
your mental and legal capabilities. Today, I'm sorry for what you've experienced. These are very excitable examples of what you've given us today. But today is December 15th, and in 232 years ago, the Second Amendment was ratified, and it says unequivocally, the right of the people to keep and bear arms shall not be infringed. That was 232 years ago today. And you cited the 2008 case, which I appreciate, but there's also a 2022 case, Bruin.
There is.
And it says that the Supreme Court has held firearms restrictions are now presumptively unlawful unless the government can demonstrate consistent with the nation's historical tradition of firearms regulation.
Yes, sir.
The historical tradition is the Second Amendment, correct?
It's part of it. Yes, sir.
Thank you.
Thank you, Senator Neal. If you could please keep it concise and brief.
It's going to be brief because I think my question has been answered. I want to thank Senator Westerfield and Ms. Austin for bringing this very important discussion to the table of this legislation. Thank you.
Thank you, sir. Representative Stevenson.
Thank you. I want to thank you for offering to allow people to give solutions and not just do nothing. And that's important. I believe in the whole Constitution. For 27 years, just like people here, I took an oath to the Constitution to defend it against all enemies, foreign and domestic. And I agree with the Second Amendment, all of them. But with every right, there's a responsibility. With every right, there's a responsibility. Even in the military for 27 years, if there was a member that looked like they were going to harm themselves or were undergoing mental health crises, we had a process. And we took away their weapon until they got healthy, and then we gave it back. We've got to be brave enough to not let people just die nilly-willy. There are a lot of dead citizens that were law-abiding citizens because we're not taking action. And we keep saying it's too hard. Well, if it's too hard, then we need to get some people that are willing to do the thinking and save the people that are living their lives right. Look at the Constitution to ensure domestic tranquility. All of that. We are the ones that were appointed. And we can no longer hide under the guise of it's abridging my constitutional rights, because everything we do in this life contends on us living for the greater good and making sure that everyone has the same right to life, liberty, and property.
Thank you, Representative Stevenson. Senator Schickel. We've asked for no.
Thank you,
Senator Schickel.
Thank you, Mr. Chairman, for your indulgence. I just have a comment that I don't think has been made, and that is, in my opinion, and I know the folks at the table disagree with me on this, but for at least the last 10 years that I've been in the legislature, we've been basically peddling a soft on crime agenda in the Commonwealth of Kentucky, and we're seeing the tragic results of those policies. And we have so many gun laws on the books right now that are not being enforced, and the perpetrators of them are not being punished. And yet we're discussing laws that potentially abridge or take away people's constitutional rights. At least that's my argument. When we have all these laws on the books already, which we're not enforcing and we're not punishing criminals for. And I just think that needs to be pointed out. Thank you, Mr. Chairman.
Thank you, Senator Schickel, and thank you, Co-Chairman Westerfield, for your presentation and your guests. And,
Thank you, Chairman.
the next item on the agenda will be Senator Harper Angel with the Crime Victims Compensation.
Roberta, I'm just going to minimize that. I don't know if I need to do anything else on the. All right.
Senator, you're recognized and you may introduce your guest and proceed. Thank you for being here.
Good morning, Mr. Chairman and members of the committee. I'm Denise Harper Angel, State Senator with the 35th District. With me this morning is the Senate Democrats' Chief of Staff, Becky Barnes. I appreciate the opportunity to be able to discuss BR 135 this morning. This is actually the second year that I've had the opportunity to facilitate a working group of victims, advocates, hospitals, and the Crime Victims Compensation Board. Last year, we came to the committee and passed some statutory cleanup language and made small increases in the statutory caps on damages. This year, we're back to propose further adjustments to the statutory caps and additional duties and simplify board procedures. Since we're short on time, I'll briefly talk about the significant changes. Senate Bill 135, Bill Request 135 requires the Crime Victims Compensation Board to make the application process available online, expand the languages with the application is available, and establish a tracking process for claims where the victims can determine where they are in the process. It clarifies those who are eligible to file claims to include spouses, siblings, personal representatives, and individuals acting as caregivers to victims of crimes. It removes the 5-year statute of limitations for filing a claim with the board. That elimination will keep Kentucky in compliance with the reauthorization of the Federal Violence Against Women Act 2022 and allow victims whose safe kits, sexual assault forensic examinations were delayed in testing to seek recovery of damages. It expands the types of out-of-pocket expenses to include relocation and temporary housing expenses, tattoo removal for victims of human trafficking, and crime scene cleanups, along with replacement of locks and windows. It also increases the statutory caps on emergency awards from $500 to $1,000, and the overall cap for reimbursement from $30,000 to $50,000. Thank you, Mr. Chair, for allowing us today to have the opportunity to speak. I look forward to coming back to the committee in the 24 legislative session. We'll have a final of the draft, and we will also have a fiscal impact statement for the committee.
I have a quick question, if you don't mind. You said tattoo removal. I assume that's for tattoos that some offender, some human trafficker has forced on a victim. Okay.
Yes, Mr. Chairman.
And what are the limits right now? You're raising it. I'm sorry. Can you go through those dollar figures one more time?
Yes, we're raising the emergency awards from $500 to $1,000. Last session, we raised the overall cap to $25,000.
Right.
Now we're taking that to $50,000.
How does one apply? And I don't remember if the gentleman from the board mentioned this. How does one apply for emergency funds versus, is that separate from a full award that you would get?
I believe that's just the first step.
Folks, thanks so much for staying with me here on this stream. Wave News reporter Sean Bowdy is in Frankfort today. He's going to have more on what happened earlier that we brought you and have much more on this story coming up later today. I hope you're having a great day so far. We'll see you later.